Our next speaker is joining us online. Unfortunately, he's joining us online because he's been traveling and we could manage to get him online. But I think it does not diminish the quality of the man who's going to be speaking, as well as the content, the quality of the content of his speech. And I think earlier on, Mr. Rose mentioned Justice Richard Goldstone. Now he's going to be speaking to us online. Justice Goldstone is a retired justice of the Constitutional Court of South Africa, to which he was appointed by former President Nelson Mandela in 1994. He is a former chief prosecutor of the United Nations International Criminal Tribunals for the former Yugoslavia and Rwanda. Very important role there. He is a vice chair of another partner of ours, Integrity Initiatives International, III, who are partnering on this anti-corruption court that Robert was talking about. He's also an honorary bencher of the Inner Temple in London. He was elected an international member of the American Academy of Arts and Sciences in 1999. It is my honor and pleasure to invite Judge Richard Goldstone to address us this morning. Let's give him a round of applause, please.
Thank you very much indeed for the invitation to address this 10th anniversary of GGA. At the outset, I would like to extend warm congratulations to Robert Rose and Deji Hastrup and their associates in this celebration of their 10th anniversary. In 10 short years, GGA has established active and effective offices in Johannesburg, Addis Ababa, Lagos, and Accra. And as we heard from Robert earlier this morning, more offices are to follow in other African countries. My introduction to GGA took place a few months ago after Robert Rose heard me speak virtually about the project of Integrity Initiatives International, III, to establish the International Anti-Corruption Court, as we call it, the IAC Court. It was typical of the amazing energy of Robert that on the day after my talk, he flew down to Cape Town to discuss the project with me. He told me that it completely aligned with his own views and that he wished to assist with furthering its progress. It did not take long, as Robert mentioned, for him to meet in Boston with Judge Mark Wolf, the chair of III, and Ian Lynch, its managing director. Within a few short months, Robert set up a separate division in GGA devoted to assisting the IAC court project, and he appointed Ruth Collifson to direct GGA's supportive role. This partnership is developing rapidly, and we in III value it greatly. GGA was founded on the recognition that most of the huge problems facing our continent are the consequence of the lack of accountability of our leaders. Perhaps the most serious problem lies in the consequence of the huge inequality that causes so much suffering by many millions of people in Africa, and especially women and children. It is the absence of accountability of too many leaders that directly links the mission of GGA to the III project to establish the IAC court. Such a court would be an effective antidote to the corruption that is depriving developing countries of 10 times more money than is received in foreign aid. Just think about that. Africa exports more in laundered funds than it receives in foreign aid. The lion's share of those laundered funds are the consequence of grand corruption or kleptocracy, the theft of public funds for personal use by our country's leaders, heads of states and senior cabinet ministers, and those who conspire with them. It is, of course, a worldwide phenomenon, but regrettably all too common on our own African continent. Only yesterday, the High Court in London dismissed an appeal by Isabel dos Santos, against the freezing of up to 580 million British pounds of her worldwide assets. Mr. Santos's father, Eduardo dos Santos, ruled Angola for 38 years until 2017. The frozen assets relate to loans made to a company personally owned by Mr. Santos. She has faced corruption charges for many years. She denies the allegations and alleges that the claims are part of a political vendetta against her. The International Consortium of International Journalists, the ICIJ, and I'll return to them later, it reported as follows in May of this year, I quote, they said, although Interpol has asked governments around the world to find and provisionally arrest Isabel dos Santos, the Angolan former billionaire is not hiding. Instead, she regularly posts about her lavish lifestyle at a Dubai residence on social media. Now, confidential land records connect dos Santos and her mother to other properties on the waterfront of the United Arab Emirates financial hub. The eldest daughter of Angola's former president, dos Santos came under scrutiny by authorities on 3 continents after the International Consortium of Investigative Journalists, Luanda Leaks investigation, revealed how lucrative deals obtained under her father's rule helped her become Africa's richest woman. Since 2019, courts in Angola, Portugal, and other countries have issued orders to freeze her assets. Despite that, Dubai has remained a safe haven for dos Santos. Close the quotes. This, of course, is not an isolated example of kleptocracy over recent years on a number of continents, not only our own. I know that you in this room are all aware of the huge amounts that are lost to corruption. However, I would like to spend just a few minutes accentuating the wide ramifications of the loss to so many nations. First, corruption is a human rights issue. As long ago as 2013, the then United Nations High Commissioner for Human Rights, Navi Pillay, said, corruption kills. The money stolen through corruption every year is enough to feed the world's hungry 80 times over. Corruption denies them the right to food and, in some cases, their right to life. Since Navi Pillay said that 10 years ago, the amounts lost to corruption have risen sharply. As we are only too well aware, in South Africa, corruption diverts crucial resources away from essential public services such as healthcare and education, and there are others. Second, corruption is contributing to climate change and is a major impediment to ameliorating it. For example, kleptocrats profit greatly from the illicit forestry trade, which is estimated to be worth in excess of $100 billion annually, and likely much more. The primary recipients of government climate-related development aid include countries that are perceived as being among the most corrupt of the world. Unless something significant is done to deter grand corruption, a large percentage of the billions of dollars in aid intended to diminish climate change will be misappropriated by kleptocrats and their collaborators. Third and last, the legions of refugees who are overwhelming countries in the Americas and Europe have been fleeing failed states ruled by kleptocrats. They include Syria, Venezuela, and South Sudan. Any effort to alleviate the world's refugee crises must therefore address a fundamental cause of forced migration, grand corruption. It is thus also a refugee issue. Coming back to the International Consortium of Investigative Journalists, the Pandora Papers, the Panama Papers, and the Paradise Papers were published in recent years by the ICIJ. We know from those sources that corrupt leaders throughout the world secretly use the international banking system to move their substantial ill-gotten gains to foreign countries. Because grand corruption pollutes the international financial system and has other severe international consequences, it is not just a domestic problem for individual countries to address alone. Rather, it is a global problem that requires a global solution. Grand corruption does not exist because of a lack of anti-corruption laws. Most of the 186 United Nations member states who are party to the United Nations Convention Against Corruption, UNCAC, have enacted the required statutes criminalizing bribery, money laundering, and the misappropriation of national resources. The problem is that some states that are party to UNCAC are governed by kleptocrats who enjoy impunity in the countries they rule because they control the police, the prosecutors, and the courts. Some of those authorities, alas, are often also corrupt themselves. Those kleptocrats will, of course, not permit honest, effective investigation of themselves or their criminal collaborators. And we must not forget the criminal co-conspirators around the world, the banks, the law firms, the real estate agencies, and other financial service providers who aid and abet kleptocrats in the transnational crime of money laundering. Domestic laws and national prosecuting authorities are simply not able to bring about those leaders, to bring those corrupt leaders and those who facilitate their money laundering to justice and to seize the ill-gotten assets. And I don't for a moment suggest that, deny the crucial importance of national domestic prosecuting authorities, but it is not enough. There is no international mechanism to bring about the seizing of the ill-gotten gains and the criminalizing of those kleptocrats. The International Criminal Court, the ICC, has no jurisdiction over the crime of corruption, and to amend the Rome Statute to include corruption is really not feasible. It would be politically fraught and more than time-consuming. I might add that the International Criminal Court does not have investigators and prosecutors experienced in corruption and money laundering. It does not have mechanisms that are able to seize and freeze illicit funds. It is in this context that there is an urgent need for the International Anti-Corruption Court. Such a court would have jurisdiction over crimes committed by nationals of an IAC court member state and crimes committed in the territory of an IAC court member state. It would have no need to invent any new crimes of corruption. The new anti-corruption court would rely on those mandatory crimes already recognized by the 186 states that have ratified UNCAC. Those crimes have thus become internationalized. They are the bribery of public officials, embezzlement, and other misappropriation of public funds, money laundering, and the obstruction of justice in relation to those offences. The IAC court would be a court of last resort. This means that it would acquire jurisdiction only in cases in which the appropriate domestic authorities are unable or unwilling to investigate or prosecute the corruption. Member states would also be able to refer cases to the court. Such a court would have a huge advantage that the ICC lacks. The IAC court would have jurisdiction acquired by the existence within member states of laundered assets. Those assets would allow the IAC court to prosecute the leaders who laundered the funds, and importantly, the power to freeze and seize those assets. And there are no kleptocrats who keep their ill-gotten gains at home. We know that. Billions of dollars of stolen assets have been laundered in a number of countries, and they include, as I've mentioned, the United Arab Emirates, the Netherlands, Singapore, Switzerland, the United States, the United Kingdom and its overseas territories, and the Cayman Islands. There are a number of others. As the Financial Times of the 31st of August 2024, Anne Applebaum wrote the following. She said anonymously owned companies and funds based in offshore tax havens behind what could be as much as 10% of the world's GDP. 10% of the world's GDP. This is money earned from organized crime or narcotics operations, stolen from legitimate institutions, or simply hidden legally with the aim of avoiding taxation, alimony, or embarrassment. In this world, theft is rewarded. Taxes are not paid. Law enforcement is impotent and underfunded. Regulation is something to be dodged and not respected. Strong words from Anne Applebaum. But this is the world that needs to be policed by the IAC court. If some of the countries where laundered funds are held would join such a court, and several are considering doing so, then illicit assets could be identified and frozen by the court. Through orders of restitution, those funds could be repatriated at an appropriate time to the countries from which they were stolen. As Robert has mentioned, we are presently drafting a treaty for the establishment of the IAC court. Of course, such a treaty would have to be agreed by governments. However, it is our belief that a draft treaty would be a practical and effective way to encourage governments to become engaged and involved. We hope to have the first draft available by the end of this year. It is our intention to use it for targeted consultations with key governments and leading civil society organizations, both domestic and international. Those consultations will further refine the draft. It is then proposed to use the product as a call to action by the international community. In this program, I am confident that GGA, as our partner, will be able to play a leading role on our continent. Our drafting committee is fortunate to have as members leading experts on relevant international criminal law from around the world, many of them from African countries. Our meetings have been hosted by a German foundation, the New Institute Foundation in Hamburg. We have met there 3 times since the middle of 2023. Our most recent meeting was held there at the end of August, just 3 weeks ago. At this most recent Hamburg meeting, we agreed to incorporate some novel provisions in the draft treaty. One of them is that the court should have 2 divisions. There will be a trial division and an assets division. The trial division would have criminal jurisdiction over kleptocrats and other high officials who have plundered their countries and those who are complicit with them, those who facilitate the plunder and the laundering of the stolen assets. It would also have authority to freeze and seize the laundered stolen assets. The second division, the assets division of the court, would settle disputes concerning those assets, whether at the instance of governments or private citizens. It would hold the assets until they can be returned to the real owners, the people of the countries who have been plundered. Unlike the case with regard to other international criminal courts, the draft treaty will recognize juristic persons, corporations, as amenable to the jurisdiction of the court. This is regarded as crucial, having regard, for example, to the role played by corporations in the laundering of assets. Money launderers for many years and for many countries have made use of shell companies to hide the ill-gotten gains. Other innovations relate to whistleblowers. In the first place, the treaty will prioritize protection for whistleblowers. They are the most important source of information with regard to corruption. They are also the most vulnerable to attacks on their very lives and those of their families. Provision will also be made to remunerate whistleblowers who provide the court with original information not otherwise ascertainable. The jurists, lawyers, scholars, and anti-corruption experts working with us on the draft treaty come from many countries, including Trinidad and Tobago, Nigeria, Brazil, Cameroon, Bangladesh, South Africa, and Mexico, as well as the United States, Canada, Australia, and New Zealand. As Robert mentioned, there are now over 300 leading figures from across the world, including more than 50 former presidents and prime ministers and 32 Nobel laureates, who have signed a declaration calling for the creation of the IAC court. Colombia was the first country to call for such a court back in 2016. More recently, the Netherlands, Canada, Nigeria, Moldova, and Ecuador have committed publicly to working towards the creation of the court. In January of 2023, the European Parliament passed a resolution calling for the IAC court. Additional countries from each region of the world have also expressed interest in the idea. The recently appointed United Kingdom Foreign Minister David Lammy has stated that he supports the court. There were positive responses in the House of Lords at the beginning of last month when Lord Peter Hain asked Undersecretary in the Foreign Office, Baroness Chapman, whether the UK government was in contact with other states regarding the IACC court. She referred to her government's willingness to work with partners in the fight against corruption and said that the UK government would engage in the discussion to establish the IAC court. Apart from Nigeria and Africa, there is strong interest from the governments in Gambia, the Democratic Republic of the Congo, Rwanda, Senegal, Zambia, and Cote d'Ivoire. It is crucial to our endeavour that there should be strong support from non-Western nations, and especially from Africa. If the IAC court is in fact or perception seen to be a Western institution, it will be bound to fail. We know well the criticisms that came from many African states and the AU against the ICC because of such a perception. This is a lesson we in III are taking very seriously. We have an active Africa subcommittee that is working closely with GGA. III is short-staffed. We simply do not have the human resources and the funding that is required to respond to the interest from so many countries, an interest that has to be stimulated by the concept of the IAC court. Pusetso Morapedi from Botswana is a young and inspirational recent addition to III. She is the only member of staff of III devoted wholly to Africa. We are appreciative that she is now able to work with the GGA through and in particular with Ruth Collifson. We're happy that both Ruth and Pusetso attended the treaty drafting proceedings in Hamburg in August. To conclude, we need far more support, financial and human resources, in order to bring the IAC court into being. In this endeavour, the work of and support from GGA is essential, and I wish GGA every success as it enters its second decade. Thank you for your attention.